Just like to welcome everyone here today to this extraordinary Ahuriri Community Board meeting. Are there any apologies?
Yeah, Hannah, hello. An apology.
They're not members of the board, so they do not need to submit an apology, but thank you for letting us know.
Yeah, thanks for letting us know there. Are there any declarations of interest? If there's not, we'll move on. So the reason we're here today is because there wasn't enough nominations on the original council election for the Ahuriri Community Board, and luckily we had 3 nominations which were the full requirement for the board, and they have been elected, and we're here today to do their declarations.
So just let me talk to the by-election report. Thank you, Mr. Chair. Just on agenda item 3.1, the by-election was not required because there was no further. That the amount of nominations did not exceed the amount of extraordinary vacancies. So the report shows you the opening closing dates and who was nominated and who has been declared elected unopposed by the electoral officer. We have Mr. Mike King, Mr. Alan Pont and Mrs. Karen Turner, and they will be taking their declarations today and before the Mayor, and the witness will be the Deputy Chief Executive, Lisa Bailey. So if there's any questions, otherwise you can seek a mover and a seconder. Thank you, Mr. Chair.
Okay, I'd like to call a mover for the declarations. Brent, and a seconder.
I'll second that.
Yeah. Steve, thanks very much. All those in favour?
Aye.
Against? Carried. Ainsley, if you can carry on, please.
Thank you, Mr. Chair. Moving on to agenda item 3.2, we're now going to take the declarations from the 3 newly elected Ahuriri Community Board members. So if I could invite the Mayor and the Deputy Chief Executive to take their places at the signing table, and then we will call on Mr. Mike King to read his declaration, and I'm just going to change the camera angle so that we can all see it.
Thank you.
That's your declaration.
You're ready to go. Do I put my hand up or no? No, all good. Just figure out. Thank you, Gary. I, Michael Douglas King, declare that I faithfully and impartially and according to the best of my skill and judgment execute and perform in the best interest of the Waitaki district, the powers, the authorities and the duties vested in or imposed upon me as a member of the Ahuriri Community Board by virtue of the Local Government Act of 2002, the Local Government Office Official Information and Meetings Act in 1987, or any other act. Nice. You can get down here. Congratulations. Thank you, Gary. Well, thank you very much. Thank you, Lisa. Thank you very much.
Mr. Alan Pont.
I, Alan Charles Pont, declare that I will faithfully and impartially and according to the best of my skills and judgment execute and perform in the best interests of the Waitaki district the powers, the authorities and duties vested in or imposed upon me as a member of the Ahuriri Community Board by virtue of the Local Government Act 2002, the Local Government Official Information and Meetings Act 1987, or any other act. Yeah.
And
Lisa?
congratulations to you.
Thank you.
Well done.
Yeah.
Congratulations.
Yeah, thanks, Lisa.
And Karen Turner.
I, Karen Turner, declare that I will faithfully and impartially, and according to the best of my skill and judgment, execute and perform in the best interests of the Waitaki District, the powers, authorities, and duties vested in or imposed upon me as a member of the Ahuriri Community Board by virtue of the Local Government Act 2002, the Local Government Official Information and Meetings Act 1987, or any other act.
Congratulations.
Okay, yeah. Thanks, Gary. If you would like to say a few words.
Thank you very much, Mr. Chair. Just take this opportunity to congratulate our 3 new members of the Ahuriri Community Board, to welcome you to the board, and really pleased. First of all, when I saw your names come through as nominations, but then to have you elected unopposed, that made obviously the process simpler and very cost effective. But we've ended up with 3 new members who bring great skills, great connections to community, and I think the next 3 years, almost 3 years, is going to be an exciting one for the Ahuriri ward, and really look forward to the contributions that you're all going to make, and look forward to supporting you in whatever way I can as mayor and as council can as well. So yeah, well done, and look forward to it. Thank you.
Thanks, Mr. Mayor, for those words. I'd just like to also just add to that, congratulations. I know we'll work as a team, and you've all got attributes that we'll need up there to get things moving ahead, and I hope we all have a successful 3 years. Thanks. I'd just like to hand over to Lisa now to read out the explanation of the legislation. Thanks, Lisa.
Thank you, Mr. Chair. I'd also like to echo the words of congratulations of our Mayor and our Chair. It's wonderful to have you joining the Ahuriri Community Board, and I'm sure the other members are delighted to have you on board as well. So I wish you all the very best. Look forward to what you're able to achieve for the ward and for the greater district. So yeah, congratulations. And now I've got the distinct pleasure of talking through a bit of legislation. So this is something we're required to do. It's in your papers. I'm going to read through some key points of the legislation that need to be outlined to you on your swearing into the board. So it is a requirement of the Local Government Act that we do this. There is 4 boards in particular that, 4 pieces of legislation in particular that it asks us to speak to: the Local Authorities Members' Interest Act, part of the Crimes Act, the Secret Commissions Act, and the Financial Markets Conduct Act. So as you can imagine, this is going to be a riveting talk. I'll highlight a few. So the Local Government Official Information and Meetings Act of 1987, which we affectionately know as LGOIMA, is really the general principle. So I'll read through this, but the stated purpose of the Act is to make official information held by local authorities more freely available and accessible. Providing access to that information, admission to meetings for local authorities, and to protect official information that is held by the local authorities consistent with public interest and preservation of personal privacy. So this is something that we work with very frequently right across council, and you'll become quite familiar with in your time on the board. So the Act is broad. It doesn't define the word information. It says official information is any item of information held by an authority. So official information is not limited to documents as you traditionally think, like letters, reports, memorandum, files, but includes sound tapes, video tapes, computer tapes, discs, maps, films, photographs, and plans, etc. So, but we can certainly provide more advice and guidance on that as we move forward. Anyone can make a request for official information under this Act, and every request has to be dealt with on its merits, and we have to make a decision whether to refuse it or to provide it, and there is some strict requirements on what we can refuse to give. In the case of refusals, the Act fixes the responsibility on the Chief Executive or an officer authorised by him. It sets out about 25 good reasons why official information can be refused. And if the grounds for refusal don't fall within one of those good reasons, then the information must be provided. Ombudsman's investigation, and under the Act, the Ombudsman can investigate any refusal by the council to provide information, and it can investigate any charges that are made by council as well. Council must give reasons for its decision, and any applicant may go to the High Court for review of Council's decision. Whatever the result of that High Court hearing, the applicant's legal costs must be paid by the council unless the court is satisfied the application was not reasonably or properly brought. There are other rights of access as well. The Act gives every person rights of access to any document, including manuals that the council may hold, containing policies, rules, guidelines, etc. And there's limited rights of refusal available to the council there as well. In terms of access to meetings, the Act provides that the public and media do have the right of access to all meetings of the council, committees and subcommittees, with the power to act and community boards, unless the meeting resolves to exclude the public. Copies of meetings agendas must be available for the public and the media also. Grounds for excluding the public and the media from a meeting can only be those provided for in the Act, and are essentially the same grounds as withholding official information. A motion to exclude must state the subject matter of the non-public matter and the specific reason provided in the Act. Order papers, also known as agenda papers, for meetings must be publicly available at least 2 working days before the meeting. Generally, supplementary reports cannot be dealt with unless agreed to by the meeting, and unless the chairperson explains why the report was not in the order paper and why the subject cannot wait until the next meeting. Section 50 of the Act provides that chairperson of a meeting may require a member of the public to leave the meeting if the chairperson believes on reasonable grounds that the person's behaviour is likely to prejudice or to continue to prejudice the orderly conduct of the meeting. Qualified privilege. Sections 52 and 53 of the Act provide that written or oral statements on any matter before a meeting of the council, committee or community board is privileged unless the statement is proved to be motivated by ill will, and the type of privilege is known as qualified privilege. It is established law that meetings of local authorities are privileged occasions. This would now include community boards. The reason given by the courts is that those who represent local government electors should be able to speak freely on any matter they believe affects the interests of their residents. Right, the Local Authorities Members' Interest Act of 1968. This Act contains provisions relating to contracts between elected members and the council, and provisions relating to elected members voting on matters where they have a pecuniary interest. In terms of contracts, the Act provides that no person can be an elected member if the total of all contract payments made or to be made by the council in which that person is concerned or interested exceeds 25,000 in any financial year and includes subcontracts. The limit of 25,000 may be extended by the Office of the Auditor General in special cases, and such approval can be given retrospectively. In terms of pecuniary interest, the Act provides that no elected member shall vote on or take part in the discussion of any matter in which that person has directly or indirectly any pecuniary interest other than an interest in common with the public. The prohibition applies where the member's spouse has a pecuniary interest and where the member or spouse holds 10% or more of the shares in a company or a controlling company which has a pecuniary interest, or either person is a shareholder and is managing director or general manager of that company. Members who are prohibited under the Act from voting on or discussing a matter are under a duty to declare to the meeting their pecuniary interest, and their abstention from discussion or voting must be recorded in the minutes. Any member who contravenes the prohibition commits an offence liable to a fine of $100, and upon conviction, the member vacates office and an extraordinary vacancy is created. We're getting there. Section 99, 105 and 105A of the Crimes Act of 1961. Section 99 defines for the purposes of the Crimes Act an official as any member or employee of a local authority. Member here would include a community board member. Section 105 provides that it is an offence punishable by 7 years imprisonment for an official to corruptly accept or obtain or attempt to obtain any bribe in respect of anything done or omitted to be done by the official in an official capacity. Section 105A provides that every official is liable to 7 years imprisonment who corruptly uses any information acquired in an official capacity to obtain directly or indirectly an advantage or a pecuniary gain for the official or any other person. Secret Commissions Act of 1910. This Act puts in legislation the principle that a person holding a position of trust, such as elected members, should not make a profit through their office. The Act provides that elected members are officers, are agents, and officers are agents of the council, and that every agent commits an offence who corruptly accepts or obtains or solicits for themselves or any other person any gift or other consideration as an inducement or reward for doing or not doing any act in relation to the council's affairs, or for having shown favour or disfavour to any person in relation to the council's affairs. While gift is not defined, consideration is. It includes discounts, commissions, rebates, bonuses, deductions, percentages, employment, and money, including loans. Section 5 of the Act provides that the agent who makes a contract on behalf of council must disclose to the council any pecuniary interest in the contract. This provision is similar to that contained in the Local Authorities Members' Interests Act of 1968. Also, it is an offence to advise the council with intent to induce it to enter into a contract with a third person and receive any gift or consideration from the third person without disclosing to the council the fact of payment. Upon conviction, any offence under the Act, an agent is liable to a maximum fine of $2,000 or 2 years imprisonment and would vacate their office. The Financial Markets Conduct Act of 2013. This essentially places elected members in the same position as company directors whenever the council offers financial products, such as an issue of debt or equity securities. Elected members may be personally liable if documents that are registered under the Act, such as product disclosure statement, contain false or misleading information. Members may also be liable if the requirements of the Act are not met in relation to the offers of financial products. Health and Safety at Work Act 2015. For the purposes of this Act, elected council members, which include the mayor and councillors, but excludes community board members, and the chief executive are by default identified as officers. And finally, the Public Records Act of 2005. This Act enables accountability by ensuring that full and accurate records of the affairs of local government are created and maintained. It also provides a framework within which local authorities create and maintain their records, and has a role in enhancing public confidence in the integrity of local authority records. The definition of a record includes information, whether in its original form or otherwise, and is not limited to just written information. It also includes, but is not limited to, a signature, a seal, text, images, sound, speech, or data in any medium and recorded or stored by any electronic device or process. In the conduct of their affairs, elected members may receive information directly, for example, from constituents. Members will need to consider whether that information meets the definition of a local authority record, and if so, will need to ensure it is included in council's records. I'm sure you all fully understand that now. Again, if there's any questions about that, any of those things as time goes on, both the governance advisor is available to help, as are council officers. Thank you.
Thanks for that, Lisa. It's very informative. We'll take it on board and there shouldn't be any problems. So with that explanation from Lisa, the meeting draws to an end. So I'd like to officially close the meeting. Thanks very much for your attendance.